Good morning, all, and this morning's video is on the subject of being autistic, lacking a social brain as part of our human variation difference, facial expressions, body language, and how that means that whether or not a court system like California or Florida are going to require mandatory autism spectrum educational training. Nevertheless, when they schedule a face-to-face, in-person hearing or trial that constitutes unlawful discrimination against someone who is autistic like me under the 14th Amendment and the Fifth Amendment to the United States Constitution, and when in a state court, Title II of the American with Disabilities Act. And why is that? Because to make that statement to any of these homogenously neurotypical judges or licensed bar members in California or Florida is like to strike at the heart of everything they learned in law school. Well, let's take a deep dive. First of all, we know that some states, like the state of Pennsylvania, are taking the education of their state judges seriously enough to have made a judge's autism bench book. But what about these other states like California and Florida? And what about late diagnosed autistic women and elderly people who are autistic and these abuses of these courts of autistic people going back decades? What about that? Well, let's start with, where does this idea of a face-to-face hearing or trial come from? Being autistic is like living in an alien world. We live in a world not designed for us, a world designed for neurotypical people. Well, the face-to-face hearing is one of those parts of our world that are designed for neurotypical people. So right off the bat, a face-to-face hearing is inherently, irreparably biased and prejudiced against an autistic person because it's designed for neurotypicals. So where did this idea of face-to-face hearings come from? It comes from the Sixth Amendment to the United States Constitution Confrontation Clause. And that is the so-called right of an accused in a criminal trial to be confronted with the witnesses against him. However, this idea of face-to-face hearings and trials is extended into civil lawsuits and administrative hearings, such as Social Security administrative law judge hearings. So this is a neurotypical, majoritarian, dominated neurotypical world design requirement being forced on autistic people who are different. The Confrontation Clause is in the Sixth Amendment of the U.S. Constitution. And let's look at the exact words of what it says. In all criminal prosecutions, the accused shall enjoy the right to a public trial, to be confronted with witnesses against him. But where in this Sixth Amendment are there any words that says that the person has to have a face-to-face trial or hearing. It isn't in the Sixth Amendment. That's not in there. Look at the plain language. Okay, so if the exact words used in the Sixth Amendment to the Constitution are saying that it only applies to a criminal prosecution, and there is nothing in those plain words that says that face-to-face hearings or trials are required by the Sixth Amendment, then who's the brainy person with the idea that somehow there's more words that we import into the Sixth Amendment that are not there, that requires face-to-face hearings and trials and extends it to civil cases and to administrative hearings and trials? Well, in 1988, here's what we have. We have a justice of the United States Supreme Court who is probably best known as one of the most original intent kind of guys, constitutional scholars. Original intent meaning you only read what the words say. You don't do any of this living Constitution stuff where you import all sorts of meanings into the Constitution that are not in the words, like they did in Roe v. Wade. And original intent guy himself, Justice Antonin Scalia, wrote this opinion called Coy v. Iowa, 487 U.S. 1012, 1988. This is the case. Justice Scalia delivered the opinion of the court, and don't get me wrong, Justice Scalia wrote great opinions. I love reading Justice Scalia opinions, but we're going to debunk this opinion. Justice Scalia quotes a couple of previous cases. We have never doubted, therefore, that the Confrontation Clause guarantees the defendant a face-to-face meeting with witnesses appearing before the trier of fact. And these are the prior Supreme Court cases here, 1987. And so Scalia says that in Kirby v. the United States Supreme Court described the operation of the Confrontation Clause as follows. A fact which can be primarily established only by witnesses cannot be proved against an accused except by witnesses who confront him at the trial, upon whom he can look while being tried, whom he is entitled to cross-examine, and whose testimony he may impeach in every mode authorized by established rules governing the trial or conduct of criminal cases. Then Justice Scalia says, well, in this other case, Dowdell v. United States, 1911, that the Supreme Court said that the Sixth Amendment right was to secure the accused the right to be tried so far as facts provable by witnesses are concerned, by only such witnesses as meet him face to face at the trial, who give their testimony in his presence and give to the accused an opportunity of cross-examination. Justice Scalia then cites California v. Green, another U.S. Supreme Court case, as saying, more recently we have described the literal right to confront the witness at the time of trial as forming the core values furthered by the Confrontation Clause. Whose core values? Neurotypical core values or autistic core values? Well, he doesn't say. Justice Scalia then says the plurality opinion in Pennsylvania v. Ritchie, 1987, stated that the Confrontation Clause provides two types of protections for a criminal defendant. the right physically to face those who testify against him and the right to conduct cross-examination. And then he says, reasons, the Sixth Amendment guarantee a face-to-face encounter between witness and accused serve ends related to both, here comes the neurotypical design of the court system, related to appearances and to reality. This opinion is embellished with references to and questions from antiquity, in part to convey that there is something deep in human nature that regards face-to-face confrontation between accused and accuser as essential to a fair trial in a criminal prosecution. And then he cites Pointer v. Texas, 1965. And concludes, what was true of old is no less true in modern times. Then Justice Scalia reasons that press release of remarks given to the B'nai B'rith Anti-Defamation League in November 23, 1953, quoted in Pollitt, the phrase still persists, "Look me in the eye," and say that, given these human feelings of what is necessary for fairness, the right of confrontation contributes to the establishment of a system of criminal justice in which the perception as well as the reality of fairness prevails. And then he cites Lee v. Illinois, 1986. And then he states, the perception that confrontation is essential to fairness has persisted over the centuries because there is much truth to it. He states a witness may feel quite differently when he has to repeat his story looking at the man whom he will harm greatly by distorting or misstating the facts. He can now understand what sort of human being that man is. Now, we're going to another case under the Confrontation Clause before we take a deep dive into why this is inaccurate, why it irreparably biases and prejudices the entire United States and state court systems against autistic people like me, and has. What it amounts to is forcing the autistic person to be in a world designed by neurotypicals, that is designed for neurotypicals by neurotypicals, but autistic people are different. The Supreme Court also decided Confrontation Clause case Maryland v. Craig in 1990. In that case, the Supreme Court held the Confrontation Clause does not guarantee criminal defendants an absolute right to a face-to-face meeting with a witness against them at trial. The clause's central purpose is to ensure the reliability of the evidence against a defendant by subjecting it to rigorous testing in an adversary proceeding before the trier of fact is served by the kind efforts of the elements of confrontation, physical presence, oath, cross-examination, and observation of demeanor by the trier of fact. Although face-to-face confrontation forms the core of the clause's values, it is not an indispensable element of the confrontation right. If it were, the clause would abrogate virtually every hearsay exception, a result long rejected as unintended and too extreme. Accordingly, the clause must be interpreted in a manner sensitive to its purpose and to the necessities of the trial and adversary process. Nonetheless, the right to confront accusatory witnesses may be satisfied absent of physical face-to-face confrontation at trial only where denial of such confrontation is necessary to further an important public policy, and only where the testimony's reliability is otherwise assured. And so in that case, the Supreme Court said Maryland's interest in protecting child witnesses from the trauma of testifying in a child abuse case is sufficiently important to justify the use of its special procedure, provided that the state makes an adequate showing of necessity in an individual case. And the process was the use of a one-way closed-circuit television procedure. This procedure required the trial judge to first determine that testimony by the child victim in the courtroom will result in the child suffering serious emotional distress, such that the child cannot reasonably communicate. And once the procedure is invoked, the child witness, prosecutor, and defense counsel withdraw to a separate room while the judge, jury, and defendant remain in the courtroom. The child witness is then examined and cross-examined in the separate room while a video monitor records and displays the witness's testimony to those in the courtroom. During this time, the witness cannot see the defendant. The defendant remains in electronic communication with defense counsel, and objections may be made and ruled on as if the witness were testifying in the courtroom. And so, by this procedure, in a nutshell, it's kind of a one-way display. So, the individual witness testifying cannot see all those people, the judge, the jury, all out there in the courtroom, but they can all visually see the witness testifying. Now, this is still violates an autistic person, even a procedure like that. And yes, as we will see from the deep dive, any autistic person pretty much, almost 100% of autistic people, and definitely I could say this for myself, will suffer such extreme serious emotional distress and trauma by being forced into a face-to-face trial or hearing that it will affect our ability to so-called reasonably communicate, because first of all, we have delayed information processing. Second of all, we cannot process dynamic information, but only static information. And third of all, we can have sensory overload, which causes an autism meltdown, or we might otherwise get selective mutism, which that's an unfortunate word, selective. It really is an autistic shutdown that results in mutism, inability to communicate. Further, what violates and discriminates against autism about this process in Maryland v. Craig, if it's used against me as an autistic person, is the constitutional violation caused by the face-to-face hearing and trial is in massive large part the fact that the homogenously neurotypical lawyers and judge and jurors are going to be looking at facial expressions, body language, and all that demeanor stuff, which is prescribed by neurotypical majoritarian court rules and conventions, and will be using neurotypical inference-based language upon viewing the autistic person who has an entirely different nervous system and sensory experience from birth, and sees the world in an entirely different perspective since birth, and where it's almost 100% guaranteed that the use of neurotypical inference-based language upon an autistic person's fact-based literal language almost 100% guarantees a misinterpretation and misunderstanding. There's no possible way to use a face-to-face hearing or trial process upon an autistic person like me without guaranteeing misinterpretation and misunderstanding that denies the right to a fundamentally fair hearing and trial. And that's a constitutional right I have. And the only way you could even possibly go with something like the process they're using in Maryland v. Craig for me as an autistic person would be if it was mandatory that all of the jurors, the judge, the opposing lawyers who are all neurotypical had to have a mandatory and adequate autism educational training beforehand to understand what it means to be autistic. And if it was a mandatory requirement without which being provided, it would be an automatic reversal of any trial result, that the court must provide an autism language interpreter translator. You have to have, when your very adversary process itself is designed for neurotypicals in a neurotypical world, and you're using it upon an autistic person, it's inflicting constitutional harm. You have to counterbalance that constitutional harm that's almost 100% guaranteed to be inflicted on the autistic person with a constitutional safeguard and guarantee, and that's what the autism language interpreter and translator would provide. Now, this needs to be said that there's an undercurrent of something else going on with this, and this neurotypical biased viewpoint of Justice Scalia. And he's not alone. You'll find that almost all neurotypicals, they panic if they can't do the face-to-face hearing, upon which they watch the facial expressions and the body language, and they even take Susan Constantine classes and other classes given to law enforcement, all this to read the body language and the facial expressions. Where do they stand and what does it mean? And what about the clothes they wear? Oh my God, what kind of social meaning, intent, and motivation? Is that a good person or a bad one? What does it mean? If a neurotypical person can't engage in that dynamic thinking process, they are lost. Because it's an innate part of being the neurotypical variant of human being for them to have to do that process. But autistic people are a completely different human variant. And as I pointed out in one of my previous videos, which I will link in the description, autistic people have now been found in scientific research, many of us, to be autistic because we have rare Neanderthal introgressed gene variants. And so we are truly a different type of human being and a different human variant. The basic fundamental flaw in this Justice Scalia neurotypical viewpoint is this idea that was handed down from the European and then English common law into the law of the United States and has percolated down, and it's actually a religious view. So when you have this view, because your entire premise and assumption to concluding that there has to be a neurotypical face-to-face hearing or trial is that there's only one type of human. Only one type of human variant, and that is the neurotypical. And that's why they designed the court system and designed it as the neurotypical world. Because they have that now proven to be wrong viewpoint. Autism debunks their viewpoint, because the existence of autistic people, a different human variant, debunks the idea that there's one type of human variant. And autistic people are equally valid human beings, and we are not lesser. Even before, science has now been demonstrating that there's more than one type of human variant. So science has moved us away from Justice Scalia's underlying belief system when he said a face-to-face hearing or trial was required. Science has moved us away from that, because you can't make the assumption that face-to-face hearings and trials work for every different type of human variant person living and existing in our world today. This is a neurotypical courtroom design. It's a neurotypical designed world, and it works for neurotypical people. But it doesn't work for everybody. So we're gonna take a little analogy here, because this Justice Scalia idea started to break down, and it was breaking down even before then and at the time, upon foreign and different language systems. And so with this legal requirement that you had to have a physical face-to-face hearing or trial, there started to be some problems. For example, I'm going to refer to, actually it comes from the Alaska courts, but you can find this in a lot of different state courts where, and even in the federal, where by Googling in, where they'll summarize all the law around the country and all this stuff about interpreters and translators in the court. And it really is not a very well-developed area of the law, in my view, because it certainly doesn't address autistic people, and when it addresses deaf people, it addresses them within the context of Title II of the Americans with Disabilities Act, qualified interpreter. But let's get at what the problem started to be that started to break down Justice Scalia's viewpoint. Here, this is an Alaska article on interpreter issues on appeal. And it's starting with due process and equal access, the due process and equal protection clauses of the 14th and 5th Amendment to the U.S. Constitution. So here we have a case where a Spanish-speaking person was convicted of murder in a New York State criminal case and sentenced to 20 years to life. He spoke no English. And so 12 of the 14 witnesses testified against him in English, and none of the testimony was comprehensible to this defendant, Negron, because he spoke Spanish and no English. So in that case, Judge John Bartels held that Negron's trial lacked the fundamental fairness required by the Due Process Clause of the 5th and 14th Amendment, and it was the first court ruling that stated that the services of an interpreter and translator may render a trial constitutionally infirm. Okay, so sometimes in the courts, these neurotypical judges, because neurotypical people, unlike autistic people, are good at imagination and imaginative play as they grow up, and pretending. And this is something an autistic person really can't do. or do very well or really understand very well. But it leads these neurotypical judges in the neurotypical dominated majoritarian court systems to make up what they call legal fictions. Now, because the Confrontation Clause was decided by the homogenously neurotypical courts to require face-to-face trials and hearings of physically present face-to-face hearings and trials, then the court had the problem, all the courts had the problem of trying to figure out just what the problem was when they dragged the defendant physically into a face-to-face hearing or trial before a judge and or a jury and opposing lawyers and maybe even the lawyer representing the accused. What was the problem when the accused did not speak the language that's being used by the court system? Well, the legal fiction that they created was that you have to have a legal presence in the hearing or trial and at other critical parts of a criminal prosecution, which then this whole bundle is imported into civil cases pretty much, and administrative hearings and trials. It's just sort of more or less this whole idea of it is. But there's some problems with that. Because first of all, it violates the due process and the Equal Protection Clause of the 14th and 5th Amendment if the accused or other person in the civil or administrative law judge hearing does not have a legal presence. Well, the legal presence is a fiction that extends and explains what the meaning of a physical face-to-face hearing and trial presence is of the accused or the defendant or the litigant in the courtroom. It's because these neurotypical people are so homogenously neurotypical, they can't move away from this innate need they have for face-to-face social interaction in the courtroom. They cannot operate their neurotypical inference-based language upon the social interaction if they do not have a face-to-face hearing or trial process. And again, that's why we get back to Maryland v. Craig and why it was a one-way screen, but the judge and the lawyers and the defendant in the courtroom still had to face-to-face visibly see the witness testifying. Well, okay, so we know that now that there's problems with this face-to-face, having to be face-to-face neurotypicality in a courtroom, because we see that happening with foreign languages, speakers of foreign languages in U.S. and state courts that cannot understand the neurotypical English spoken language. And so basically, so far in a civil case or administrative law judge hearing, at least the higher courts keep coming down with the conclusion that, well, it's up to the discretion of the judge. And then, of course, the court budget kicks in, and they absolutely will not. I mean, they may say they will, but they, at the end of the day, they do not provide autistic people who do not speak the neurotypical inference-based language with autism language interpreters and translators. And so there's nothing in Title II of the ADA, for example, enforcing the due process and equal protection right to an interpreter translator that says that qualified interpreters are only for deaf people. There's nothing in the ADA that says that. So again, you got these neurotypical people, they compartmentalize to very narrow situations. They have to decide things based on stereotypical categories. That's how neurotypicals categorize their information. They take a gist. The gist is a stereotypical gist of, say, what a dog is, what a cat is, what a bar applicant is, what a lawyer is, and what a litigant is. And they get the gist, they state the gist, they make all these detailed assumptions from the gist, few facts that they pick out. And so, in the case of qualified interpreters, it's still a neurotypical designed world. Most of the people at the U.S. Department of Justice enforcing disability rights are homogenously neurotypical, because all of the state bars pretty much are homogenously neurotypical. They have been, since they started this eugenics thing decades ago, and used all sorts of psychological tests to exclude autistic people from bar membership. So you still have this problem, but there's nothing in Title II of the ADA, or even can remotely be read into the due process or equal protection clauses, that if you're going to say legal presence requires an interpreter or translator for people who do not speak the neurotypical English language used in the court systems in the United States and the states, there's nothing that says autistic people would not be entitled to qualified interpreter and translator for analogous reasons to why deaf people are, or why a Spanish speaker is. So that's sort of the underpinning of all of this neurotypical idea and concept, why it has to be a face-to-face hearing or trial. So there are many law review articles and other scholarly articles about demeanor evidence and assessing credibility, that is the truth-telling of a litigant or a witness in cases. But I'm going to use one because I found it had a lot of case citations to how neurotypical judges are using this demeanor evidence, and that is an article that actually comes from immigration asylum cases. But it may be important because foreign languages are an issue in almost all asylum cases. I know. I took refugee law in law school, and I'm autistic, and I'm being forced to live in a neurotypical world. Right here, it comes from Georgetown Law University here. And this is an article where COVID-19 all of a sudden cluster smacked this confrontation clause idea of face-to-face hearings and trials in the courts because of the pandemic. Immigration courts had began using video teleconferencing instead of the physically present face-to-face hearings and trials. And that caused a neurotypical freak out! A freak out! Because the neurotypical people, if they don't have a physically present face-to-face hearing and trial, their brain short circuits and they go haywire, and they can't socially interact, so they can't assess anything about truthfulness or what the facts actually are. So the article points out that in a Supreme Court case of 1895, Mattox v. United States, the Supreme Court said the primary object of the constitutional provision, the Confrontation Clause, is to give the accused an opportunity not only of testing the recollection and sifting the consciousness of the witness, but of compelling him to stand face to face with the jury in order that they may look at him and judge by his demeanor upon the stand and the manner in which he gives his testimony whether he is worthy of belief. So judges are often left with the task of determining whether the litigant or witness is telling the truth. And so judges are given extraordinary deference in making credibility findings which they can base on factors such as, and here comes the neurotypical world. It's a neurotypical court design. This is the neurotypical inference-based language. In real time, judges are given extraordinary deference in making credibility findings, that is, whether the person is telling the truth, of litigants and witnesses, which they can base on factors such as the litigant or witness's demeanor, candor, responsiveness, inherent plausibility, and any inconsistencies, inaccuracies, or falsehoods in testimony. Assessments of demeanor include one's outward appearance, look, and behavior are given particular deference. This deference is grounded on the American legal tradition's belief, that's the neurotypical belief, the neurotypical norms and standards and expectations, that assessing demeanor is an accurate way to ascertain the truth, and the assumption that the trial judges are in the best position to assess demeanor because they observe the litigant or witness in person during live testimony. Now we get to the autism problem. For example, courts can make adverse demeanor findings based on the litigant or witness being agitated, visibly nervous, or when their speech becomes notably faster or has an almost desperate tone when responding to difficult questions. Courts can point to a lack of emotion when discussing traumatic events to support an adverse credibility finding. And here it comes. Lack of eye contact can be a basis for an adverse credibility finding. You heard that right. If you are autistic and you can't look a neurotypical in the eye, then the judge can say, you are not telling the truth, you are lying, and you are not to be believed, and you lose your case. This is, if law schools had to give a mandatory class in Autism 101, this would be Autism Discrimination 101. Bias and prejudice irreparably prejudicing the outcome of the case. I mean, can you believe they actually are admitting this and saying this? I mean, this is what they're teaching all the neurotypical lawyers and judges. This is how they're teaching them to assess all the witnesses and litigants, which happen to include 1 in 36, basically, large cross-section of autistic people in these hearings and trials in the court systems. It doesn't matter whether it's a criminal trial, a civil trial, an administrative law judge hearing to get disability benefits for being on. It doesn't matter. These are the neurotypical court designed rules about how they decide whether you win or you lose your case. You could very easily do a find and replace of that statement there of the word immigration or immigrant with the word autistic, and that would be a very accurate observation of what happens to autistic people in any court in the U.S. or state court or administrative law judge hearings and trials. Decades of research by social scientists have shown that the nonverbal cues commonly associated with deception are based on false assumptions. Contrary to beliefs, stereotypical visual cues like not maintaining eye contact, facial expressions, hand gestures, and body movements do not occur significantly more when an individual is lying compared to when they are telling the truth. Some of these visual clues, including fidgeting and shifting postures, in fact decrease during actual deception. Further, the number of cues people associate with deception are greater than those that are actually indicative of deception, resulting in false positive. As one scholar summarized, empirical findings demonstrate that the behavioral cues used by jurors and other observers, that would include judges, to perceive and measure deceptive discourse are more strongly associated with judgments of deception than with actual deception. In other words, a wipe of the hand, a lick of the lips, or a stammer in a witness's speech will yield a judgment of deception far more often than a deception on the part of that litigant or witness actually occurs. The result is that the ability of neurotypical humans to distinguish truth from lies based on a speaker's behavior is only slightly better than flipping a coin. Cross-cultural misunderstandings are endemic to immigration hearings. Cross-cultural misunderstandings are endemic to immigration hearings because asylum seekers, by definition, are from other countries. Mannerisms, facial expressions, and body language mean different things in different cultures. The most well-recognized difference is the Western association of eye contact with honesty. Look me in the eye and tell me the truth. Well, in other cultures, averting one's eyes is a sign of respect and deference. People from different cultures may use different facial expressions to convey emotions. Other nonverbal expressions such as emotion, non-emotion, hesitation, becoming visibly uncomfortable, or changes in tone, speed, and volume of speech can be misinterpreted between cultures. These differences are stark, and their impact on perception is exacerbated by the general public's lack of awareness of these differences. Further complicating cultural misunderstandings is the impact of implicit biases, unconscious feelings, beliefs, and stereotypes that permeate decision makers' thinking without them even knowing it. Scholars have highlighted the deleterious impact of implicit racial or cultural bias in legal proceedings. Behavior-based credibility assessments are grounded in expectations of how a litigant or witness should act or behave in a courtroom, which in the United States is a traditional white and male-dominated space, but it's also a neurotypical-dominated space. People whose behavior or speech patterns diverge from expected norms are often viewed as unreadable or unreliable. These implicit biases can seep into the reasoning of even well-meaning individuals, judges, who self-identify as impartial and fair without them even realizing it. The continuing reliance on demeanor as an indicator of credibility thus allows the interjection of the subconscious influence of stereotypes and selective empathy, leading scholars to theorize there is a demeanor gap along lines of culture, race, and gender, while also neurotypicality. As a result of the deference being afforded to these demeanor findings by appellate courts in the United States, all that is required is that judges articulate what specific demeanor traits led to their adverse conclusion. Lack of eye contact, aggressive or defensive tone, flat affect. They do not need to dig deep to explain why they believe the identified trait indicates untrustworthiness. So long as their decision is a neurotypically plausible view of the evidence, it will survive appellate review. And this leads to tainting their decision making and resulting in the denial of the case. And so the article goes on and says that tone, pace of speech, cultural context, and other nonverbal cues imbue words with meanings and that many words or concepts defy demands for exact word-to-word translation because language is inherently ambiguous and contextual. Human communication is inextricably tied to culture and shared reference points. The intended meaning of uttered words and the listener's ability to understand that meaning also depends greatly on paralinguistic features such as intonation, volume, and speech rate, as well as nonverbal communication like physical gestures. Misreading or omitting these paralinguistic cues not only affects the judge's ability to understand the litigant or witness, but also the litigant or witness's ability to understand questions from the bench, which can lead to answers that appear as dodging the question, hesitation, or being non-responsive. Further, some studies suggest that if there is an interpreter in the immigration court anyway, the interpreter's voice, dress, mannerisms, linguistic competence, age, race, and gender can affect assessments of the litigant or witness's demeanor. In sum, credibility findings based on demeanor are fallible and unreliable even in in-person hearings and trials. The inability of the judge to accurately discern truth from lies based on behavioral cues is further compromised where cultural misunderstandings, implicit bias, imperfect neurotypical inference-based language interpretation, trauma, and stress muddle already murky determinations. Demeanor assessments are neither probative nor fundamentally fair and thus fail to meet even the minimum standards of evidence in court. The realization that demeanor is an unreliable indication of credibility has led legal experts at home and abroad to call for an outright prohibition or diminished reliance on demeanor considerations in credibility assessments. I'm not talking as to myself about being in any immigration court case, but I'm taking this article on this reading the facial expressions, body language, and all this stuff, demeanor evidence, to determine the truthfulness of the litigant or witness and what are the facts in the case, because it's very analogous and many of the same concerns impact autistic litigants and witnesses. So it's very on point to now the deep dive into being autistic in a neurotypical designed state or federal court or administrative law judge agency hearing or trial process where they want to have and are requiring a face-to-face hearing or trial process. And I'm an autistic litigant or witness. Now, I'm going to start this deep dive with some of what Yosemite Sam has to say, because it's very enlightening.
A lot has been written about more specific common or uncommon autistic traits, and I feel like this is where a lot of people tend to miss the point. I'm sure many people who have been diagnosed as adults will have tried to explain their autism to somebody at some point, only to be met with, well, we all do that. We are actually humans, slightly different humans, just running on a slightly different operating system. But because we're humans, our autistic traits are human traits. Now, humans already describe themselves in terms of traits. They have all sorts of descriptive words that we assign to people. People might say, I'm a real chatterbox, or I'm quite shy. These are traits. And all of these things that we use to describe ourselves are generally accepted under the banner of acceptable human experience. The thing about autistic traits is that they are written in a way that is meant to exclude, to shame, or to let us know that our way of being is not normal and not acceptable. We have deficits, we are lacking, we are broken or wrong. But when you look into it, every autistic trait is really just a human trait wrapped up in a negative package. You know, you hear as autistics we make poor eye contact, we have difficulty socializing, which are both very pathologizing ways of describing something that is inherently neutral. You could completely rewrite the neurotypical experience to be just as pathologized if you wanted to. I could say, I've discovered this new disorder, called neurotypical spectrum disorder. And people who are suffering or afflicted with this disorder often have poor attention to detail. They might have an obsession with meaningless small talk, social status, and ritualistic exchange or social grooming. They may demonstrate a lack of interest in exploring their favorite topics deeply. They will take part in many activities at once, aka multitasking, at the expense of all of them. They have a linear thought process and an inability to think outside of the box on a daily basis. In all seriousness, I am doing the exact same thing as the way that the criteria are written for autism to the neurotypical population. It's just rewriting the behavior with a negative slant. What I said before, it's kind of an accurate description of neurotypical culture. It's just written in kind of a nasty way. But this pathologizing of autistic traits has a negative impact on autistic children and adults, because it sends the message over and over again that we are wrong. So how can we talk about autistic traits in a way that is still accurate but not pathologizing? Well, I would say to make it factual and ask autistic people about that trait from their perspective without the filter of a neurotypical lens and the judgment that piles on. Take away the value judgment and suddenly you understand autism a heck of a lot better. So we don't make poor eye contact. That's an example of a value judgment. Somebody is saying that our eye contact is not good enough. But you could say we find eye contact painful or uncomfortable, or simply that we prefer to concentrate on what the other person is saying rather than trying to concentrate on that and the expression that they've got on their face at the same time. Likewise, we don't have restricted interests. That is another value judgment based on how many interests this person thinks we should have or is appropriate. Instead, you could say we become experts very quickly on a specialist topic, or often several, and find great joy in pursuing it. And so you see, eventually, once you've gone through all the autistic traits in a similar way and rewritten them without the value judgments, they suddenly become a lot more understandable, more human, more real, and at the same time, less disordered. Now, flipping around traits to see them in a neutral or positive way is not about reframing the autistic experience as just a positive. We don't have to love being autistic all the time. But it's about being able to be realistic about our strengths in a world that only seems to care about our weaknesses, deficits, and struggles. And many autistic people do have strengths that they are keen to show, but everything is set up in a way that makes us feel like we're failing anyway. School, university, the workplace. We struggle in these areas often because of the way that they're set up. It's a systemic issue, not an individual one. So now that we've started to flip the idea of autistic traits being automatically a bad thing, and we've started viewing autistic traits as human traits, there are some people who use this to slip into the idea of thinking,
but doesn't that make us all a little bit autistic?
And actually, sometimes when you start learning a little bit about autism and the ways that it can manifest in our behavior, it's kind of easy to slip into this mode of thinking. But autism is a genetic neurological condition. You either have it or you don't. It's made up of a large variety of different genes that we don't really know how they all interact. But research has found specific structural differences in various areas of the brain, as well as differences in the way that neurons are connected to each other. So it is a physical difference in the way that the brain has developed. So if you've ever seen a t-shirt or a badge or something that says wired differently, this is why our brains are literally wired differently. And this is why behaviorism doesn't really work, because no outward change can change the fact that my brain is different. I can mask just as much as I like, but it's not going to change the way that my brain naturally works. My brain never fundamentally changed in this. So I've said that autistic brains are different from neurotypical brains on a fundamental physical level. Autism is a complicated one, because it encompasses so many areas of our daily life, physically, mentally, and emotionally.
So what we can see from Samdi Sam's presentation, and this is where the Florida state court system completely misses the boat, because there's no indication that the Office of State Courts Administrator in Florida, or their statewide ADA coordinator, Debbie Howells, or even the Chief Justice of the Florida Supreme Court in official capacity ever listens to the presentations of actually autistic people. So, but if you do, and you listen to what Yosam Sam has to say, we can instantly see, we become enlightened, that Florida's autism segregation vexatious list is just more of the same old pathologizing language about autistic people used to create prejudicial negative stereotypes because they're describing autistic traits in a biased, prejudicial, and very negative and harmful way to put people on the segregation list. And you could do a negative slant to neurotypicals if the court system had a predominant autistic majoritarian composition, and you could equally well do the same thing to neurotypicals. So we know that this entire autism segregation vexatious law and statute, and the way they go about conducting their court proceedings to reach those results, to make autistic people lose their cases, to put them on this autism segregation vexatious list, to deny us economic remedies, to deny us restraining orders against people who are trying to harm us, neurotypical people, and even to incarcerate us, are based on the entirety of a neurotypically designed court system where the entire striking at the heart of the court system is biased and prejudiced against autistic people, such that autistic people cannot get a fundamentally fair and impartial trial process. So this is the background for now diving deeper into this. How do you know the litigant or witness before you is a liar? You're using the neurotypical designed demeanor evidence. It is so pervasive that you can actually make the statement and the conclusion that by simply noticing a face-to-face hearing or trial in a neurotypical dominated court against an autistic litigant or witness itself constitutes a discrimination and exclusion violation of Title II of the ADA. You don't have to look for all the nitpicking little reasons within the face-to-face hearing or trial. It's the type of hearing itself. And again, the Confrontation Clause of the United States Constitution, nowhere in the words it uses, says it has to be a face-to-face hearing or trial. The Founding Fathers knew better than that because some of them were autistic. And they wrote this Constitution before the majoritarian capture of the entire federal court system in the revolution of the takeover when they did the 1938 Federal Rules of Civil Procedure to eliminate those people with encyclopedic knowledge who spoke a different language. That is, the autistic people, to exclude them from the court system, to capture it and seize it and dominate it and design it in the neurotypical worldview. Because that's what has really happened. And it's wrong. And they can't deliver a fundamentally fair and impartial trial to any autistic person. And I know that firsthand from my experience through various courts. The thing about autism, that the Florida state courts, all of the opposing lawyers in the homogenously neurotypical Florida bar and in the homogenously neurotypical Florida court system don't understand. And this is what they ridicule when they say that people who have an oversensory difference, they're vexatious litigants. Those people who experience sensory nervous system differently than us neurotypicals, they're vexatious litigants. And we don't like them and we don't want them in our court system. That's autism discrimination. Because the thing is, autistic people, the entire human person, of the autistic person, in that person, the entire nervous system is wired differently from before birth. And I'll get to some videos on that. It's not just a so-called brain-based mental classification. There are physical differences throughout the body of an autistic person and physical traits of being autistic. Being autistic is a physical disability as well as a neurological evolutionary disability. The evolutionary part is seen in the developmental trajectory of an autistic person. And so because of this, there is no neurotypical person hiding inside an autistic person. Autistic people don't experience a neurotypical worldview. Autistic people don't have neurotypical experience. It's neurotypical common sense. We are an entirely different type of person. Our own tribe, our own evolutionary tribe of a human variant. And we are equally human. So when we become pathologized by this neurotypical majority who has seized the Bar Association memberships and our court system, starting in 1938 with the overhaul of the Federal Rules of Civil Procedure, this pathologizing that is nowhere found for face-to-face hearings in the actual words of the Sixth Amendment of the U.S. Constitution. That's just neurotypical gloss that was painted on top of the Constitution to make it neurotypical, to favor and bias court cases to go in the favor of the neurotypical people and against the autistic people. So now we have to understand that there is nothing at any minute of any day, of any week, of any month, throughout our lifetime, where an autistic experience is going to be neurotypical. Autistic people have an entire different sensory experience of the world and an entirely different perception of the world and an entirely different worldview than neurotypical people. And it's equally valid. And, you know, we really don't care if neurotypical people don't like that. We don't care. You're violating our constitutional rights. We don't care what you think. What we want is we want you to stop violating our inalienable constitutional rights. That's what we want. And you cannot do that as long as you keep noticing face-to-face hearings and trials. You simply cannot do that. And here's why. Okay, so keeping this in mind, that the Florida state courts and the federal courts all want face-to-face hearings because the entire bar associations and court systems in almost every single state in this country, including but not limited to California and Florida, are almost 100% homogenously neurotypical. That's one type of human variation of living human today. The other is autistic human variation. That's every 1 in 36 people in the United States, and it may be even much higher than that. So we can't have this quasi-religious idea that there's only one type of human, a cookie-cutter neurotypical stereotype that there's only one type of human, or this view that there's only one type of human and that's all we're considering in the court systems. Because, well, it violates due process and equal protection, for one thing. I've taken the viewers through Yo Sam D. Sam's pointing out that depending on what type of human variation has domination and control as the majoritarian group of these court systems will depend on if they want to slant their narrative. They can bias, prejudice, and slant their narratives against the other human variant type by pathologizing language. And how, because neurotypical people are in charge of the court systems now in the states and federal in the United States, including especially in Florida and California, that what you have is a neurotypical designed court systems by and for neurotypical people. And so if we were talking about a product, you would say it's a design defect. It's a defective product. Well, we're talking about a court system and their methods of operation, their methods of administration, their rules, the services they render, and how they operate the court system. And so I've taken the viewer through these rules that the neurotypicals have designed into these court systems, where they freak out if they don't have face-to-face hearings so they can do their dynamic interpretation and their neurotypical social interpretations and their facial expressions, and they're reading the body language and all this stuff that tells them through their neurotypical inference-based language of the motives and intents of the litigants standing before them. They use this demeanor evidence. This demeanor evidence is mandatory in order to determine credibility. Credibility is if the litigant or the witness is telling the truth. Being perceived by the neurotypical judge to not be telling the truth is an actual and proximate cause of an autistic person losing their case. And as we'll get into in my next video, there is this, what they call 4x4 or 5x5 rule that they're using in the Florida state court system, where they count up the number of cases the autistic person loses. This is a pretextual proxy for inability to look me in the eye. So one of the primary ways in which a neurotypical judge right off the bat decides if an autistic litigant is lying, so the case is frivolous and therefore vexatious, and they lose the case and they get put on the autism segregation list, is, can the autistic person look the judge in the eye? We have known since at least 2007, based on the extremely popular book by John Robison, Look Me in the Eye, My Life with Asperger's. This is in the mainstream media, this book. So you have this Florida Supreme Court so-called vexatious litigant work group. You have Task Force 1 and Task Force 2. So you cannot say that these people on the task forces or the Chief Justice are unaware of one of the most talked about and popular books that's been discussed in the mainstream media since 2007, that's just as famous as Rain Man, the movie, and that is John Robison's book, Look Me in the Eye, a New York Times best-selling book. And so what does Look Me in the Eye have to do with autistic people losing their cases? Well, it's almost a 100% guarantee that when the autistic person is made to go to a face-to-face hearing in a state or federal court in Florida or California, and the autistic person cannot look the judge in the eye, that the judge is going to use the mandatory demeanor evidence that's discussed already in this video to decide that that autistic person lacks credibility and is a liar. And if the autistic person is a liar, then the autistic person is lying about the merit and validity of the case they have brought and about their claim. And if they have done that, then they lose. They lose the case. The case becomes adversely decided against that person. And then they're counted up under this 4x4 or 5x5 rule that is a direct proxy for the inability to look in the eye, an autistic trait. The 4x4, 5x5 rule is a direct proxy for being autistic, and it's counted up to put autistic people on this denial of court access autism segregation vexatious list maintained by the clerk of the Florida Supreme Court. And obviously, the Florida Supreme Court must be hunky-dory happy with it because they've done nothing to stop this. They, according to the public records responses I have received from the Florida Supreme Court, they don't supervise their clerk. They don't have mandatory jurisdiction to review anyone being put on this list. And in addition, they haven't corrected their vexatious litigant workgroups 1 and 2 to order them to review this problem with the demeanor evidence, whether someone's truth-telling or lying, and it's an impact on whether their claim is perceived as valid or frivolous. And this is just a big ouch in the Florida court system. It's like willful ignorance. It's like, how can 111,000 plus lawyers and all these justices and judges in Florida not talk about this? Because they don't want to. They don't want to, and they're not going to change things until the autistic community and autism families and parents who have children who get caught in these court systems or become adults and get caught in these court systems start demanding change and say that they don't want a court system that on its face discriminates against autistic people. Facial expressions are part of the evidence evaluated in the credibility truth-telling component by the demeanor evidence. It's a type of evidence, and it's very significant because we all know the courts give these official transcripts, and they're not using part-time transcripts with officially trained and certified real-time transcriptionists, and they're not filing them with the appeals. When to meet due process for an autistic person, they need to be doing that because these real-time court reporters need to be explaining every single item of nonverbal communication going on in the courtroom to the autistic litigant, and they're not doing that. So you've got these cold transcripts, and they make the illegal discriminatory assumption that there's one type of human variant, and that's the cookie-cutter neurotypical, and they understand what's being communicated with nonverbal communication, and that's not true. Facial expressions, body language, and all this other nonverbal communication is as high as 80 to 90% of communication going on in a courtroom. Now, this is a Psychology Today article that's quibbling with that, but it does admit that this 80 to 90% statistical finding, and that it applies to cases where one's verbal and nonverbal gestures are incongruent. So when is a litigant's or witnesses' verbal and nonverbal gestures incongruent? Welcome to Autism 101. When the litigant or witness is autistic. And that's just a trait and characteristic all of the neurotypical judges and lawyers, bar members, would know if they had mandatory autism educational training. But they don't. With John Robinson's book, we have to deem that they do know this and that they are willfully ignorant. Why? Because as Jacob Munch Esquire, Florida bar member, said to me one day when I asked him to respect my autistic way of communication, I don't want to practice law that way. Oh, so the neurotypical bar members don't want to practice law in Florida in a way that makes communication and the understanding of what's going on in a case in a courtroom equally accessible and give equal opportunity and full participation to an autistic person. But he's not alone. As an autistic person, I have frequently heard this come out of the mouths of neurotypical Florida bar members. And the sentiment is very clear that it also comes from neurotypical judges within the Florida state court system and sometimes in Florida's federal courts, as it did in California.
Back to the As We Will, guys, a place where we think differently daily. What's going on, different thinkers? Whew, yeah. So, autism and facial expressions. I wanted to do this video because I find it really interesting. The inside and the insight about autism and facial expressions and understanding facial emotions, because we all have facial expressions, we all have facial emotions, but it's super interesting when it comes down to autism. Now, as autism impacts the communication part of the brain, it's no surprise that autistic people have a major issue with trying to understand and identify facial expressions from a person. And this means, like, if somebody is sad or angry or upset or inquisitive, the facial expression that they pull will not be communicated in that way to the person who's on the autism spectrum. So the autistic person won't look at their the person having a conversation with and look at their facial expressions and say, I know this person's been crying about something, or I know that they're upset or sad. It's very difficult to do that. Now, there are a few reasons for why this may be an issue. First off, it's common for autistic people to not really make eye contact, right? We all know, and I've done a bunch of videos on different traits of autism, and one of the most prominent ones is making eye contact is difficult for people on the autism spectrum, so they're never really looking in the eyes of a person, and maintaining eye contact is super difficult as well. So, for a person to have lack of eye contact, then they're not looking at someone's face. So how would they even know what facial expression you're pulling if they're not looking you in the face, right? Which is really interesting. There is another reason, though, that the communication part that impacts the autistic person can interfere with the way that you track and observe emotions in people's faces. So how you identify if somebody's feeling a certain way, right? An emotion that comes out from a person's physical appearance is that you track their emotions through their facial observations. So you look at their face and you say, well, they look like they're crying, or they're laughing, or they're happy, or they're sad, or whatever. And that is how you can convey that the emotion that they have in your mind. It's kind of like a knowing how the other person's feeling, and kind of like trying to judge their kind of next move, because if they're crying, they're going to want to wipe their tears away, and might want to go to the toilet, wash their face or whatever. So it's really difficult to judge what's what. Now, autistic people have a huge issue with this, and I myself actually have a huge issue with this. And it's funny because I don't know if someone's angry, sad, or upset or whatever, unless they're like crying, like really, really upset and crying, or unless they're really happy and they're laughing. And I know those two because there's more than just looking at their faces for this. Now, the other ones in between is difficult. I feel like everybody's grumpy all the time, and that's all I can see is just people being grumpy. I can't really tell if someone's happy or not, which is really difficult to kind of like figure out and passively understand. But there's another part that comes with autism and facial expressions, right? That autistic people can't identify facial expressions in people or emotions through facial expressions, but then also autistic people have a bad time actually conveying their own emotions through facial expressions to other people. Now, my girlfriend always says to me, like, why are you angry? What's going on? I'm like, oh, I'm not angry. She's like, oh, you got such an angry face on. And I'm like, oh, no, I'm just just hanging out. So she can't understand why my facial expression doesn't match up to how I'm feeling, which is really interesting. She said it yesterday as well. She said that, like, when I'm happy, I don't show happiness through emotions on my face. I probably just say that I'm happy. And this is really interesting. So it's really interesting. When you're dealing with people on the autism spectrum, you have to be mindful of the fact that they may not understand the typical forms of communication that you take for granted, and the other way around, that their form of communication may be totally different from yours, and they may not understand what you're doing either. So, when you're looking at an autistic person and trying to figure out if they're happy or sad from looking at a facial expression, that ain't ever going to happen, and you're never going to be able to figure that out, because it's just not something that happens. It's not a formula that's going to work. You have to either ask them or know them to know if they're happy or sad because of the situation you're in, basically.
It's actually become a thing among actually autistic people on YouTube and likely elsewhere to do videos about their lived experience taking facial recognition tests. And almost all of these videos come up with the same or a similar conclusion. All these facial expressions look the same to autistic people, and they get an F. And yet, here are the courts saying autistic people cannot look in the eye. That's under the demeanor evidence, so they're going to lose their case, because if they're a liar because they cannot look in the eye, then they're a liar about their case having merit and being a valid claim, and so therefore they're vexatious and they lose their case, and then the Florida court system counts up these cases under a blanket 4x4 rule that's so vague. They don't care why you lose the case, because the counting the cases rule itself is an autism discrimination proxy. It's a proxy to discriminate against autistic people because it's a proxy for people who cannot look in the eye. So therefore they lose their case.
Is typical of someone with Asperger's. Although highly verbal, their restricted interests precipitate over-focusing on one particular subject to the point of being a little professor. They tend to talk to people or lecture them rather than talk with them in a reciprocal social manner. Dr. Atwood reminds us that reciprocal conversation is not instinctive to those on the spectrum. Medically speaking, they truly don't understand.
That often the person with Asperger's syndrome is confused and unsure of what to do. And when they make a mistake, people say, well, I shouldn't have to tell you this, you should know. And the fact is they don't know.
Most studies on autism have been done with visual stimuli with facial processing, and they've looked at kind of activation differences, and there are a number of differences that show up in regions that we know process facial input.
As a result of the differences revealed in the MRI imaging, Dr. Plauché gives us an example of how very difficult it is for Aspies to read facial expressions and to process the meaning of conversations we engage in every day.
I can really tell I feel very different from other people. Like, let's see an example. Well, sometimes I guess I feel like I have the mind of a child, in a way. And of course, I don't like to look people in the eyes.
Not looking people in the eye is a great difficulty for those with high-functioning autism and Asperger's syndrome.
So as you look at what it must feel like, we really are starting to understand much more that there's a true, it's not just, I don't want to listen to you, or I don't want to engage, or I don't want to give you eye contact. It's a true breakdown in perceiving people's body language, even perceiving tone of voice, facial expressions. Those things don't register in the same way that they do for a neurotypical brain.
The part of the brain that deals with all of this simply doesn't function. The inability to read facial expressions is why they have trouble empathizing with others. It isn't a matter of a lack of empathy, rather it's the inability to notice emotions in others.
When we look at this neurotypical design defect that the homogenously neurotypical lawyers and judges have implemented in our state and federal court systems, especially in California and in Florida, we can see that it's no more than assumptions, junk science, pseudoscience, if even that, and it's inaccurate, and it stacks the deck to irreparably prejudice any case, all cases, all claims against an autistic person. And these neurotypical Florida bar members and California bar members and California's and Florida's judges, state, federal, they don't care. It's a medical proven manifestation of being autistic that is manifesting in this behavior that these demeanor rules that's mandatory for judges to use to decide who's lying and who's telling the truth, which is the actual and proximate cause, whether they perceive, these neurotypical judges and lawyers, an autistic person's case or claim to be valid or invalid, have merit or be frivolous and vexatious, that is at issue here. It's the status of being autistic that we cannot look in the eye. Immutable traits and characteristics of being autistic that these judges and lawyers are evaluating with the demeanor evidence to say the autistic person is lying and not telling the truth. These neurotypical judges and lawyers are lying when they say, well, we didn't know that person was autistic. That's because, well, first of all, because it's been in the mainstream media, what is a bestseller, John Robinson's Look Me in the Eye. So if these neurotypical lawyers and judges like actually live in our world, they know about autism. They know about the impact of autism would have on a court case. And they willfully choose to ignore it. That's equal to intentional discrimination, intentional irreparable bias, and prejudice. It doesn't matter if they say, well, I didn't know you were autistic. There are behavioral giveaways that a litigant standing before them is autistic, whether they have an autism educational course or not. And that is what they're reacting to when they do these dismiss the case, punish the autistic person, and sanction that person like 100 times more than their lifetime earnings. And just terrible abuses of autistic people like that continue to go on in California's and Florida's courts today.
Join me as we discuss outward signs that might be giving away your autism. So what are the 3 things that other people might pick up on as you being different facial expressions? It is your tone of voice, and it is your gestures. According to the CDC, in a report in 2020, 1 in 34 boys are identified as having autism, while 1 in 145 girls. And I believe this is much higher in girls. I just feel like it's just undiagnosed for years and years for many girls, as it was in my case. I'm diagnosed at the age of 48. It's unusual for my husband or son to say, what is wrong? And are you okay? And I'm like, yes, I feel happy. Is my face not showing that? Knowing their answer is no, because I can't. So maybe you struggle with inconsistency of facial expressions, gestures, and tone of voice. That is definitely the case for me. In fact, when I was diagnosed, she definitely noted that I had intonation in my voice. And here's what intonation means. She also noted that I used poorly modulated eye contact to initiate or regulate social interactions, and I showed limited range of facial expressions.
It's not just that autistic people like me have the inability to look in the eye. There are also other gestures, voice intonation, posture, body movement, and other aspects that become included in this judge evaluation of demeanor evidence to determine if the autistic person is lying or telling the truth, that then results in the success or the loss of the autistic person's case. So, for example, there's not just 5 senses that we all have. There are actually 8. And autistic people are impaired in many of these senses that neurotypical people are not. And this is medically based, and it's an immutable trait and characteristic of being autistic. It's something that we cannot change, and it's something that gets mocked and trivialized, marginalized, and punished in these court systems by the homogenously neurotypical bar members and judges in California and Florida's court system. This extends to bar examiners. This neurodivergent doctor explains.
Good morning, Neurodivergent Nation. This is a Neurodivergent Doctor. And my question to you is, are you a person who's always hot? Are you sweating profusely for seemingly no good reason? Do you strip down the moment you walk in the door and hope that your kid didn't bring some friend home that you didn't expect? Or maybe like I've been my whole life, where you're constantly cold and you can't seem to heat up. What about forgetting to eat all day, or being chronically dehydrated because you don't drink enough, because you don't recognize that internal cue that tells you that you're thirsty? Are you one of those people who dresses wrong for the season, like shorts and t-shirts in 38-degree weather? It's right for you, but everybody else is like, why are you dressed like that? If you've answered hell yeah to any of these, you may be having difficulty with one of your senses, but which one? So you've heard of the 5 senses. You know touch, taste, sight, hearing, and smell. The real 6th sense is actually what's called our vestibular sense, which is all about balance and posture. But this video isn't about senses 1 through 6. It's not even about our 7th sense. But real quick though, our 7th sense, before I move on to the 8th sense, our 7th sense is proprioception, which is our ability to know where our body and our body parts are in the space around us. This is something I spend time with my clients talking about after diagnosis of autism. Someone who struggles with proprioception might constantly be bumping into things, have lots of bruises they don't even know where they came from, and difficulty knowing where their body parts are relative to their other body parts. So think tripping over your own feet or smacking your hip with your own arm. That's not what this video is about either, I know. But today I wanted to talk about the 8th sense, which is interoception, and the problems a lot of our neurodivergent nation deals with. Basically, interoception is a person's conscious or non-conscious sense or awareness of what is going on inside their body. Interoception problems are not only having to do with things that I talked about at first, like body temperature regulation problems, not recognizing hunger, thirst, etc., but they might also include issues like bladder control problems, extreme fatigue, difficulty properly interpreting emotions, and getting hurt or burned without noticing right away. And these are just a few examples. But that's not all. Check this out. It also has a hand in controlling your autonomic motor system, which is breathing, intestinal functions, blinking, heart rate, eye dilation, and more. No. I'm not done yet. Guess what? This is also the main mechanism for our fight or flight response system. So let that percolate in your mind just for a moment. Just process this. This is the main mechanism for our fight or flight response system. If you're having interoception problems, you're likely having problems controlling some or all of these functions I just mentioned. And you may be in states of panic and anxiety more often. And this may make you stand out to others, preventing you from going out in public places with confidence and ease. And it may play a role in so many other things that are common traits of autism. Wow. I mean, who knew so many issues could be tied to this one sense that never really gets talked about? Okay, so let's break this down into bite-sized chunks. You know this is what I like to do. You see, we have sensory receptors throughout our body, in our muscles, in our skin, in our joints, even in our bones. And 90% of these are what is called free nerve endings, located in the outer flesh and skin. These pick up on sensations and send signals to our brain about them, and in turn, our brain figures out how to regulate many of our organs and functions, which keep us in a state of homeostasis, which is just a fancy word for balance within the body. Homeostasis helps us prepare ourselves for the day and helps us interact well with others. When a person has some challenges with their 8th sense, they can experience lower self-awareness, difficulty problem solving, sounds like ADHD too, doesn't it? Challenges with looking at other people's perspectives, social understanding problems, cognitive inflexibility, trouble deciphering where feelings of empathy are coming from, and emotional recognition and regulation problems.
A person might experience a rapid heart rate at inappropriate times. They might have heavy breathing at inappropriate times. Why do so many have a problem with this, and how does it affect them? Why are some struggling with less while others experience more of it? Isn't that just like autism, though? Just when you think you've figured something out, half of the autistic people out there, they experience something different, just the opposite sometimes. That's one of the reasons it's so tough for neurotypical people to study autism and draw conclusions. Autism is a huge multidimensional phenomenon, and our understanding of it is just in its infancy. Another part about research on this subject of interoception is that it draws correlations fairly well, which means it's been identified that many autistic people experience diminished interoception, but they don't necessarily know why they experience it more often than the general population. There's also research that suggests that interoceptive awareness can actually be heightened when depression and anxiety are present. This means some autistic individuals who experience anxiety or depression or both may actually feel their internal cues more, which causes completely different types of problems.
These interoception impairments in an autistic person like myself have a huge impact on the court case. I'll do another video on how it affects being present in the courtroom itself when the lights are too bright, there's too much noise, there's too many people are talking at once, there are horrible food and chemical odors and smells from the people and the courtroom itself. And I'll do a more in-depth dive into the courtroom and what the Honorable Monica Brazington, 8th Judicial Circuit of Florida Circuit Judge, said when she said, well, this case is going forward, but if the courtroom's not accessible, you'll have to take that up with Alachua County. These interoception impairments in autism, they are disability impairments. They are physical disability impairments. So being autistic is a developmental evolutionary human variant that has physical disabilities, neurological disabilities, and comorbid mental disabilities. It's not just a mental disability because it's mentioned in the DSM-5, and I believe another YouTuber, Ember Green, talks about that. It's there, but nowhere does it say it's a mental disability. So, being autistic rewires the entire central nervous system differently than in a neurotypical person. And part of being autistic is a physical disability. Also, autistic people have an impaired sense of proprioception.
Proprioception is our sense of body awareness. It allows us to know where our body parts are positioned without looking at them. Perception is our sense of our bodies. It allows us to feel our muscles and joints, like when we stretch or contract our muscles, and experience hugs and deep pressure. If you're undersensitive to it, you may lack awareness of your body's position, so may bump into and lean against things, use too much or too little pressure, such as when writing or break and drop objects. You might like rough, rigorous activities, and like tight clothing and spaces, so as to feel your boundaries. You might have difficulty sleeping and sitting still, love biting or hard and chewy foods, have anxiety in open spaces, so like to stay close to the walls. You might have difficulty sitting still and physically stim and move around a lot. If you're oversensitive to it, you may be very aware of your body, and so feel slight movements in your muscles, and mistake tension for pain. Because of this, you may avoid movement, like sports and exercise, and avoid physical contact like hugs. You may move slowly and carefully to avoid contact with objects. You might also dislike heavy clothing, blankets and bags, feel claustrophobic, and so feel anxiety in tight spaces or crowds.
So an impaired proprioception can result in the autistic person in the face-to-face hearing being perceived by the opposing neurotypical bar members and judges as standing in the wrong place, or too close to somebody, or too far away, or too close to the wall, or not having the right posture, bumping into things, all sorts of things upon which this junk pseudo demeanor assumption nonsense operates, upon which the neurotypical judge is determining if the autistic person is telling the truth or lying, and causing whether or not the judge thinks they have a valid claim or a frivolous and vexatious claim. It's not a small thing, because this is an immutable autistic trait and characteristic. It's something the autistic person does not necessarily have control over and cannot change. It is manifested in the autistic behavior and so-called demeanor.
And what I'm going to focus on today is motor impairments. And in the DSM, these are listed as an associated deficit. And specifically, it's listed as odd gait, clumsiness, and other abnormal motor signs. So a little broad, a little vague, but certainly recognize that this is a common co-occurring deficit. So why is motor function important in autism and in general? Well, motor development is one of the earliest benchmarks of developmental progress and is crucial in driving multiple cognitive processes. And these advances allow an infant and a toddler to engage with the environment, manipulate objects, engage with other caregivers, and develop spatial perception. Motor impairments are prevalent in many neurodevelopmental disabilities, particularly in autism, and perhaps are posited to be even one of the first signs of atypical development. We also know that motor development can be observed and measured over time, and that it can serve as a target for intervention, predominantly using things like physical and occupational therapy. But of course, in this talk, we're going to consider other avenues as well. Here in this slide really represents a recent study showing the prevalence of motor difficulties in autism. And they found, based off of predominantly caregiver reports, the Vineland Adaptive Behavior Scale, that 35% of these individuals met criteria for motor difficulties, almost equal to the rate of intellectual disability, which was 37%. The prevalence of motor difficulties increased with age, and also with difficulties in nonverbal communication. Yet, diagnosing clinicians only reported motor difficulties in about 1.3% of cases. Despite the fact that these are prevalent, these often go underscreened and underdiagnosed. This next slide further highlights that prevalence of motor impairment. And I won't really go into detail in this text-heavy table, but what I want to point out is in the first column, it's been shown that motor dysfunction or impairment in multiple motor domains. So in gross motor coordination, fine motor, and then what we call sort of higher level motor abilities like posture, imitation, balance, and praxis. And in the following two columns, what it really highlights is the prevalence of motor dysfunction from infancy all the way through adulthood in autistic individuals. And that impairment and impact can be on language, cognition, social communication, and of course physical activity. Despite this prevalence, though, and understanding and importance of motor function and motor dysfunction in autism, they do often go under-recognized and under-screened.
It's not only impaired interoception, proprioception, motor impairments, but even more recently, autistic people have been found to have Parkinsonism-like autistic traits. So, for example, Google's AI overview says that although autism and Parkinson's disease are distinct neurological disorders with different underlying causes, they share some similarities. So, people with autism are 3 times more likely to develop Parkinson's-like symptoms, such as tremors and freezing while walking, than the general population. Parkinsonism in autistic adults, middle-aged and older autistic adults, are more likely to have Parkinsonism such as poor balance and bradykinesia. There is some genetic overlap between Parkinson's disease and genes implicated in autism. Both autism and Parkinson's disease can include repetitive behaviors of a compulsive nature. When these neurotypical bar members and neurotypical judges in these court systems in California and Florida, state and federal court systems, and these administrative law judges doing adjudicating claims like disability claims, when they've got an autistic litigant or claimant before them and they're applying this mandatory demeanor evaluation under the neurotypical designed defective demeanor rules, they're analyzing sometimes motor impairments as well as Parkinsonism type impairments. These are atypicalities in the way the autistic person moves and stands, and slow or fast, what they look like, over which the autistic person may not have any control. They are immutable autistic traits and characteristics, and they're analyzed under these demeanor rules to junk science, whereby the neurotypical judges decide that the autistic person is not credible, they're not telling the truth, they're a liar. And so they're not only a liar about the evidence, but because they're a liar about the evidence they have, they're lying when they say they have a meritorious claim and they should win their case, because the neurotypical judge uses this junk demeanor science to say the autistic person is a liar, so they're also a liar about their claim is invalid, and this frivolous and vexatious is applied to deny the autistic person all court access and to stigmatize and stereotype that autistic person as a bad and broken person in a way that shows up in background checks and will deny that autistic person a job, being able to rent an apartment, being able to qualify for a mortgage, getting any kind of a loan, just virtually every single opportunity in life. It's a form of oppression of autistic people being perpetrated by these willfully ignorant, homogenously neurotypical dominated courts. Because there's physical impairments of being autistic, nobody's even considered in a Florida state court, for example, whether these demeanor rules and this autism segregation vexatious statute, Florida statute 68.093, actually are unconstitutional under Florida's Constitution, Article 1, Section 2, Basic Rights. No person shall be deprived of any right because of physical disability. These are inalienable rights, among which are the right to enjoy and defend life and liberty, to pursue happiness, to be rewarded for industry, and to acquire, possess, and protect property. So, I've had my liberty taken away from me, as well as property, by being put on this autism segregation vexatious list. On the basis of these demeanor rules that have misinterpreted, because it's a design defect, a neurotypical design defect in the neurotypical dominated Florida state courts, to use these demeanor junk science rules to almost guarantee 100% misinterpretation of an autistic person and their immutable traits and behaviors through which the autism manifests. I have been my liberty denied by being denied all court access, by taking real property away from me. None of these neurotypical judges or bar members want to. They don't want to, but remember, they're the learned profession, so they know all about this. They don't want to recognize that their actions have violated my rights under Article 1, Section 2, Basic Rights of the Florida Constitution, or taken property away. It is so bad that one of these days they're going to have to create an autism look me in the eye innocent list and give a new trial in every civil and criminal case and administrative law judge claim when the person is autistic, because it denies a fundamentally fair and impartial hearing and trial process. Not to mention abuses autistic people. I know when I applied for a public member vacancy on the Florida Board of Bar Examiners, and I lost my balance and leaned against the wall on my way out, I could see these terrible faces being made by all Florida Board of Bar Examiner members when that happened, like they were shocked and horrified. And then I got a denial letter. So it's really clear to me that because of my proprioception and motor impairments of being autistic, they denied me that public member vacancy position because I'm autistic and discriminated against me. It doesn't appear that these Florida Board of Bar Examiner members either, just like the judges in the courts, the neurotypical bar members and judges in the courts in Florida, it doesn't appear that they have any autism educational training. But there's more. And this one is really shocking. It shocks the conscience. These neurotypical judges in these courts can even decide an autistic person is lying about their testimony, their evidence, and even the validity of their claim if they don't meet neurotypical expectations and the clothes they wear and how they dress. In the disbarment case of my husband, David Frank Petrano, that is the Florida Bar v. David Frank Petrano, Florida Supreme Court case number SO14-2287. During the trial before referee Singletary, the abusive, autism-ignorant Florida Bar prosecutor James Fisher made the following argument to referee Singletary. Basically, I'll paraphrase it. Your Honor, you just have to look at Mr. Petrano's shirt. It has some stains on it and a little rip. And this needs to be evaluated under the Demeanor credibility evidence. Well, what's wrong with that? It's because it impacted me, because my husband was directed to be my lawyer by the Florida Office of State Courts Administrator as a reasonable accommodation to the Florida State Court system for my being autistic. So I get to comment on the abuses of him in his disbarment proceeding because these abuses took my reasonable accommodation away. And that affected me and impacted me. So I get to talk about this. My husband believed he was autistic on the basis of a special education placement he had in the public schools as a child in Rochester, New York, and based on certain characteristics that would indicate that he is very likely autistic. And James K. Fisher, for one thing, we learn in law school that if you got some unfavorable evidence, that you cannot just decide you're not disclosing it at all to the adjudicator, the judge, the referee. That is lying by omission. So James K. Fisher lied by omission by not telling referee Singletary that, well, there's a situation where 9 out of 10 people over the age of 50 who are autistic are undiagnosed. And by not informing the referee that, well, if you go on spaces on the internet where autistic people congregate, there are a lot of people who are self-diagnosing themselves as autistic. And by not telling the referee that there were no doctors at that time, basically, that were diagnosing adults in Florida under an autism diagnostic assessment. Those were lies. And he procured my husband's disbarment with those lies. You know, even more so. If James Fisher wanted to show the referee that my husband wasn't autistic, all he would have had to do is point at something and see if my husband's eye gaze followed the point. I've been taught to follow someone pointing. That's been drilled into me, just like some autistics get drilled and look me in the eye. I don't naturally follow somebody pointing. My husband never had it drilled into him. He doesn't have the joint attention to follow somebody pointing at all. And James K. Fisher could have tested his autism right there in the courtroom. But he didn't want to, because he was a liar, and he lied prosecutorial misconduct to obtain the disbarment of my husband. Why? For filing Title II ADA cases, because the Office of Florida State Court Administrator directed that he had to be my attorney as my reasonable accommodation to the court system. Another fact that James K. Fisher omitted to disclose to the referee. He's just a big fat liar. All he did in the courtroom is grandstand that he wants to be a judge. He's one of the people that's probably the least likely person any member of the public would want to see be a judge. Let's get back to this Demeanor comment about what my husband was wearing. Because my husband, he doesn't like to wear clothes because he has an interoception problem of being too hot. So he takes his clothes off around the house. And he's got a big issue with clothes. There's lots of clothes he can't wear. They're too scratchy or they don't fit right. He's got a clothing problem. So do I. I have a huge clothing problem. And it's very common that autistic people can't wear clothes that's got scratchy tags in them. We're oversensitive. It causes a meltdown and sensory overload.
Hello, everyone. You may be wondering why I'm coming at you today looking like hot garbage. But I promise you, I have an explanation. Today, I wanted to talk to you about one of the main comments to that point was actually something that I should have thought about and we'll talk about now. And that is, Claire, I actually only wear the same things over and over again. I don't have a lot of variety in my wardrobe. I dress the same way every day. I wear the same things over and over again. Why don't we talk about that? You're totally right. The autistic uniform is a real thing, but it might not be exactly what you thought. Every single person who is on the autism spectrum is different. I know it's crazy to think about, but it's true. We all like different things. We all wear different things. We all have different interests and hobbies and etc., etc., etc. When I'm talking about an autistic uniform, what I'm talking about is the phenomena that autistic people find something that they like to wear, just like we find things that we're interested in, special interests, and we stick to wearing that thing. This can change throughout our lives, but once we find something that we feel strongly about, you'll notice that we wear that thing over and over as many times as we can. It's our comfort clothing, our uniform, our autistic uniform. That's why I look like this today, because at this current moment, I would say that my Tom shoes, my black leggings, and my gray sweater are pretty much my autism uniform. This is what I wear when I don't have to be anywhere. This is what I wear when I do have to be somewhere. So for me, recently, the past few years, it has been a gray sweater or a sweater similar with a crew neck, comfy yoga pants, and slip-on shoes. Socks, not all the time. Socks, I get uncomfortable with socks. That's a whole nother autism thing. The thing about this is that this is not a new idea for me, but it might be a new idea for some of you to think about. I look back at my life and I always wear, in different periods, similar outfits throughout those periods. First thing I wanted to say is that the autistic uniform is a personal thing. So it's what the individual feels comfortable in, it's what they like wearing, it is an easy choice for them, it has basically passed the sensory tests needed for us to be able to wear clothing, and it has passed the I like this, it's my safe clothing choice. And it makes getting dressed a whole lot easier when you've got sensory issues. 2, the uniform that we choose is normally comforting and calming. So it has fabrics that we find calming and comforting. It might have an image on it that we like or find interesting or special interests. Also picking out things that are comfortable to wear as far as the fabric. Things that I wear, I don't want to feel tags, or heaven forbid you ever leave one of those plastic tags in. Ugh. Right? So our autistic uniform is something that an autistic person will choose to wear to help themselves stay regulated, stay comfortable, help themselves be more social. But it is a thing.
So my husband, David Petrano, this was one of the shirts he wore every single day. It was one of the shirts that he felt calm and comfortable in, that didn't bother him with scratchy tags or that kind of thing, because those around him believe that he is autistic. It doesn't matter about the lies James Fisher told. This shirt had been washed. This shirt was clean. It had a little tear because we lived on a farm. And I have fine motor impairments, as does my husband. So it was a struggle with our fine motor impairments to pick up a needle and sew that. There's a little teeny tear, maybe an inch long. But that was enough for the Florida Bar's prosecutor, James K. Fisher, to make the Demeanor evidence argument to referee Singletary that my husband was a liar and dishonest and he could not be believed because of the demeanor of the shirt that he was wearing. This is for real. This is how Florida lawyers can be disbarred. Something as autism discrimination as attacking the sensory clothing that a person who says he's autistic is wearing. This is just kind of the totality of my video now that we've gone through about this problem with face-to-face hearings and trials in these neurotypical majoritarian-dominated courts. It's why, if they're going to be using these demeanor rules to assess whether an autistic person is telling the truth or lying and their claim is valid or frivolous or vexatious, because it guarantees an almost 100% misinterpretation and misunderstanding. It's designed to do that. So the only way you could have a fundamentally fair and impartial trial or hearing, if you're going to allow those kind of rules, would be to have a constitutional safeguard, and that is the appointment of a qualified autistic language interpreter and translator who can tell the judge at every single step of the way, with a CART real-time certified reporter on a CART real-time transcript that gets filed with the reviewing court, that you cannot use neurotypical inference-based language to interpret the autistic literal language, fact-based language, that way. They're not doing this, though. They are not doing this. And I will do another future video on why it's just a line of malarkey when they say they cannot do this. Because we don't live back in the world of handwritten books with scribes in a medieval Dark Ages library anymore. We live in today's world of AI. So for them to say that is just, it's a mockery. It's discrimination on its face. And in fact, when you go through the totality of this video, you can easily see why. If you look at the docket of a case or a claim, and you see that no autistic language interpreter was appointed for the person throughout all critical stages of their case, and especially at the hearings and trials, why that's the face-to-face hearing constitutes autism discrimination on its face. It's because these demeanor rules are not being eliminated when the person is an autistic litigant or witness. They are used against the autistic person in an irreparably biased and prejudiced way to stack the deck in favor of the neurotypical opposing lawyer and have the case go against the autistic person no matter what it is. Autistic people do much better if they get the reasonable accommodation of being able to testify behind a computer keyboard. And I'll do more on that in a future video and why that is. But I want to leave the ending of this video with the other thing that happened at my husband's disbarment case. The Florida Bar versus David Frank Petrano, Florida Supreme Court, SC 14-2287. And obviously, since the Florida Supreme Court disbarred my husband, they approved of this. And that is that, first of all, the Florida Supreme Court entered in an order banning my husband from Florida Supreme Court access because he made a request for reasonable accommodations, not only for himself with the Florida Supreme Court for this disbarment case, but for me as his autistic witness, in a direct response to his request for these reasonable accommodations under Title II of the ADA. The Florida Supreme Court ordered that he was a vexatious litigant and he was barred from all access in the Florida Supreme Court for life unless he filed pleadings signed by a neurotypical Florida Bar member. And so we went to his trial, and on the first day of his trial before referee Singletary, we both said we cannot proceed. We cannot proceed without these reasonable accommodations. So then Judge Singletary and the trial court administrator, J.K. Buddy Irby, in the 8th Judicial Circuit, they had a mad scramble. And they didn't know what to do, and they got the cartwheel time in place, and it was all ad hoc, and they let me testify by typing on my computer. But they didn't give me the true autistic accommodation I needed, which was for them not to be viewing my demeanor evidence and assessing the credibility that way. And worse, here's the big time violation of me that referee Singletary made. And if the Florida Supreme Court was at all concerned about the integrity of a disbarment proceeding or it being fundamentally fair and impartial, they would have reversed on its face just because of this violation. What happened was, I was typing and testifying, and I have fine motor impairments because I'm autistic, and the first thing that happened was the villainous, nefarious Florida Bar prosecutor, the liar, James K. Fisher, he said to the referee, and I want you to take note in the record of every time she makes a typo. I mean, what is that supposed to prove? That I'm autistic? That I'm a liar? What is that supposed to prove? We don't know. But the prosecutor wanted that to be relevant evidence in the record. And then they didn't just take the transcript of what I typed and put it in the record as my testimony. Oh no. They had to have neurotypical J.K. Buddy Irby with neurotypical tone of voice and pitch and rate and rhythm read what I typed into the record. So my credibility was evaluated to disbar my husband on the basis of the neurotypicality of the rate, rhythm, volume, pitch, and neurotypicality of the voice of J.K. Buddy Irby. It is such a conflation of witness testimony. It violated due process on its face. I mean, it's just wacky and absurd. But that's what they do because they don't have any specific mandatory autism educational training in the Florida state courts or of every single Florida bar member. And I was violated. And I get to talk about this due process violation because it took away my reasonable accommodation attorney to access the Florida court system, directed by the Florida Office of State Court Administrator, which was my husband, and also because I was repeatedly, viciously attacked and vilified in my husband's disbarment proceeding, where I could not defend my good name because I was not made a party to the case, and James K. Fisher did this to be able to reach out and prejudice my Florida bar admission. So that's the video for today. If you like my videos, thank you for watching. Please hit the subscribe button, ring the bell, and you'll be notified of my future videos.